Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, attorney Giselle Ayala talks to us about Shaquille O'Neal's endorsement agreement with Papa John's. So, let's tear it down. How are you today, Giselle?
Hi, Mike. I'm good. Thank you for inviting me.
Giselle, I have to tell you a story. Briefly, I was standing in the kitchen. My son was at the microwave, and he was making something, and just randomly, 14-year-old turns to me, and he goes, "Dad, what do you do for work anyway?" And I said, "Son, I think I might be an influencer." He laughed, and he said, "No, seriously, what do you do?" So sarcastically. What we're going to talk about today, Giselle, is on theme. We're going to talk about influencers and how I'm sort of a big deal by making a reference to this document. I'll share it here. This is an endorsement agreement between Shaq and Papa John's. Giselle, tell us about this document. What is it? When are we going to run into documents like this?
Well, this agreement is an endorsement agreement, and it's very interesting to know that you may confuse sometimes endorsement agreement with something called sponsorship agreement, which is different. When you have a sponsorship agreement, you actually provide services to someone to support something. An endorsement agreement, you are promoting a product.
Right.
And it's really interesting that it's in writing, especially with big companies and big celebrities like here. You may find this contract when you want someone who may drive content and may drive an audience, to have interest in a product. Endorsement agreements are very important because whoever is endorsing your product or your service is actually a personality that has the potential to influence the conduct of consumers.
Right.
And nowadays, like, social media, TikTok, Snapchat, all these different platforms who have given space for like new influencers to appear, we will find in different scenarios where attorneys want to advise these new influencers on how to deal with this contract, what kind of things they can expect if they're just starting and they encounter a big company who's been in the market for a long
Right.
time.
See, and that's what I'm saying. Like, I can convince my 14-year-old that I'm a big deal because there are contracts, and there's only contracts if there are big deals, son. So, before we get into that, tell us about you a little bit, Giselle. What's your background? What brings you to documents like this?
So I'm from Colombia. I am an attorney foreign admitted in Colombia, but I'm also, of course, admitted in the US. I founded my law firm 2 years ago, which is called JM Law Office, and I work with entrepreneurs. I work with Latinos who are entrepreneurs and getting into this different like entertainment field. But the focus also is to advise immigrants and Latinos who actually don't really have a clear understanding of U.S. law, especially since it is a common law country, and sometimes that may reflect in different applications of the legal systems.
Gosh, I'm imagining coming into the United States in this super weird media environment that we're in and becoming a Latino influencer and trying to figure this nonsense out while trying to figure the culture out. It's super interesting. All right. Well, here's what we're going to do, Giselle. We're going to go through this agreement between Shaq and Papa John's. We'll go over a few sections that sort of stood out, and then at the end, we'll talk big picture to try to persuade my 14-year-old that I'm a big deal. So let's start up at the top. Just give us a bit of background on this document. As I recall, and we were talking about this before, there was a relationship between Shaquille O'Neal and Papa John's pre the relationship that became famous because Papa John's CEO was kicked out and Shaq joined the board as a way to sort of revive their public image. But at this time, this document is 2019. What's the relationship between Shaq and Papa John's at this point?
Yeah, so Papa John is entering into this agreement with Shaquille O'Neal. The idea is that he will endorse and promote, the different products that they have. In that sense, the contract tends to be broad because they mention like what are their products, and they say like pizza, restaurants, entertainment spaces. When the ideal is to eat pizza, so around that unique product, there's a lot of to talk about in terms of what Shaquille O'Neal is promoting. He is chosen because he's a celebrity. He's someone, it's a basketball player who has been, in the industry of sports for a long time. So he has a lot to offer in terms of, promoting the image of Papa John's commercially and driving new consumers and making the product kind of young and interesting. That's why the first thing we're going to actually find is the definitions. And one of the most important definitions is the definition regarding celebrity, because when it comes to endorsement agreement, these are agreements that usually an enter into because the personality, because of the specific personal features of the celebrity who is going to endorse the product. That's why that definition is so important. It's actually, it gives sense to the document, right?
Right.
So the celebrity, it's a person who is known, and the definition specifically states like what kind of things are available for use by the company who is receiving that endorsement, like trademarks, likeness, copyright, personality rights. That's very important. And the other concept that is important in this part of, like, I mean, all concepts are important, but I'm highlighting these two because are those that are most focused and are those concepts which could be important in case of litigation. And the other concept is like competitive products, or those products that are being endorsed and which place the celebrity in a specific place when he should not and is probably not be allowed to promote or endorse other products that compete with the company's products. So those are two important definitions for us because it will give us like a roadmap of what to expect from the contract.
So to get to that, those two definitions are up in the definitions section. But I'm getting down to the grant of endorsement, sections A and B. And I guess give me just an idea of the media relationship. So you mentioned the difference between endorsement and sponsorship. It sounds like it's not that Papa John's is saying, okay, Shaq, you've got a podcast. It's a big deal. Everybody knows what it is. We're going to give you money to say Papa John's, Papa John's, Papa John's 10 times. That's a sponsorship agreement. This sounds like they're agreeing to create new media with the face of Shaq. Is that right? Is that the distinction between those
Exactly,
two
yeah.
kind of
Packaging
agreements?
is going to create like new media content, advertising material, basically. And Shaquille O'Neal is like the center of that media. He's going to be photographed next to Papa John's trademarks. He's going to be photographed with the pizza, next to the restaurants, promoting the brand, the colors. They are going to actually use his publicity rights, his traits, to put them there for the public. But when it comes to that media relationship, Papa John's is going to create that content, but it has to be approved by Shaquille O'Neal because he is a celebrity.
Right.
He is in a specific position when he also wants to take care of how he is portrayed to the public.
Okay,
Also,
well, we'll get to the approval, but before we do, I want to
exactly.
nail down this work made for hire concept, and people who do this kind of work, those of you who are writing this, you know what this is, but for simplicity's sake and for viewers who may not know, tell us what that work made for hire distinction is, and do you like the way in B under grant of endorsement under 3, do you like the way that 3B talks about Shaq's work made for hire? So what is it? Do you like the way they frame it?
Yeah, so work for hire is a very important concept because it is related to the copyright protections of works of authorship, creative works. What happens is that if you don't actually include a work for hire clause or definition, you may have an issue, legal issue regarding who is the owner of a copyright and who has the right to exploit it economically, to go to court, to create actually derivative works. So they include this work for hire provision so that all that material that is advertising, which is protected under copyright, it's owned by Papa John's. So they are sure that if something happens and one day, Shaquille O'Neal wants to go walk out of the agreement, they have the ownership of that advertising material and they can exploit it, create new works from that. They can use it for economic purposes, and that's not going to be an issue. So the work for hire definition is basically saying that whatever is created with Shaquille O'Neal, with the celebrity, when it comes to economic rights and copyright enforcement, it's
Mm-hmm.
owned by the advertiser, the company.
Right.
That's why it's so important. Yeah,
Yeah,
it's
and I'm thinking about like I have done these things. I've been hired by companies to write an ebook or to write a book or whatever, and they have the ability to then turn that into whatever they want. But, that is a very open, it makes sense to start with that, to say this is work made for hire and we can do whatever, we want to do with that. But for the celebrity or for the person whose image is being used, that can be scary, right? That can sound like they can go and, take my image and do a deep fake and make it so I'm saying all kinds of things. But what they add into this that I think is interesting, and you had mentioned this is a reflection of Shaq's power in this relationship, is the approval process. So let's go down to E and to one general. Tell me, what is the approval process, and do you like the way they've framed this?
So here the approval process is that Papa John is going to set some dates, of course, on schedule to work with Shaquille, and they are going to create this content. But they have to send it to Shaquille for approval. They have to. Shaquille has the right to approve the concept, the way like the advertising piece is created, and even the channels of communication for that advertising. Once they send this piece for approval, the first time, let's say, if there is no answer from Shaquille O'Neal, he actually states there that the piece of advertising is going to be deemed as not approved, and that's like a security measure. If sometimes these celebrities have a really really tight agenda and they have different compromises, so if they cannot really have like their legal team or their marketing team to review something, they probably prefer to say we have not approved this. But of course there have to be some kind of equilibrium, between the parties. There has to be reasonability, and for that they say if you send it a second time and we have not answered, you may think, you can assume that it is actually approved, because if there was anything kind of a red flag, we will actually say something. We will not like receive it a second time, if there's something wrong, keep silent. So that's how you handle this and make a contract something reasonable.
Yeah, and I'm looking down at 4 in that same section. They talk about it sounds like they don't want Papa John's to be able to go out to the world and say we're Shaq's favorite pizza just randomly, for the rest of forever. Even on in terms of whether they're representing that he's doing work with them, it sounds
Yeah.
like Shaq's team needs to approve even a press release. What do you think about 4 in that same section?
Exactly. I think that when you talk about a press release, you are also involving additional things, like it involves the press, and you will have other legal issues, like like freedom of speech. If something goes wrong and someone says puts Shaquille O'Neal in a false light or in a way that he doesn't want to be portrayed, and if we have like constitutionality issues regarding freedom of speech and the freedom of press, it could be very complicated to keep risk small. So I think that's why it's so important here this clause, which I haven't see it in all contracts. I think some celebrities maybe don't think it is important, and maybe don't think they are as famous as they would to be able to actually include that. But someone who is well known like him wants to actually control the narrative again. And when it comes to the press, you want to have more control, because then you are also dealing with third parties, and you may not be able sometimes to limit what's being said or how is it being said.
Yeah, speaking of press, let's jump down to the social media post. This is in B of 4 under services. So the thing with a personality like this, especially now, is the reason anybody trusts anything that he says about anything is because he's genuine. He is seen as a person who wouldn't, sell his identity, which of course he is, but that he wouldn't make it up. You would expect that he probably actually likes Papa John's. At least that's what people would believe. Social media, I think, is a really interesting because, like, the brand Papa John's wants to know that you, Shaq, are going to go do something with this. So you have to post these ads at least once a month, and we'll do the language, and you guys will approve it, and it'll go through all this process. Where's the balance between that, knowing that you got a deliverable, and the genuineness that people come to expect? Do you like the way this agreement deals with an obligation about social media representations?
Well, here what happens is that the responsible for compliance with advertising, which is basically concern about not having material that is deceptive or misleading for consumers outside, the responsibility of compliance is fully for Papa John's, basically, because they are the ones who are advertising. And I think the clause it's well drafted. I will probably add something like, well, depends. If we have a celebrity that doesn't have a lot of experience, you may want to really highlight it, or like call to the attention of the celebrity that there are these guidelines, and they have to, like, their team, especially if they don't have a marketing team, if they are like maybe on their own doing TikTok videos or something like that, they have to be aware of the fact that they have to make these disclosures. Of course, the other party, the company Papa John's, is fully responsible for the content. But if the influencer alone is going to be doing the publication of this on Instagram, Twitter, whatever, they have to remember that there are these guidelines by the FTC, and they have to include maybe a tagline or a capital letter saying advertising, endorsed material, so that the public knows that he's actually receiving some kind of compensation for that picture where he's portrayed next to Papa John's trademarks, brands, or products.
Yeah, I
I
remember the
think it's,
early days of the internet when people would do this kind of work and there was no disclosure about anything, that they
yeah.
were paid to hold this can of soda or that these are affiliate links or anything. And then people sort of swung the other direction and just claimed responsibility for everything. What I like about this agreement is it's saying, look, there are requirements and here's who's responsible for them. I mean, Papa John's is taking on the requirement that they will clearly and conspicuously disclose to the public that ABG and celebrity have been paid by Papa John's. They're saying we're going to own that. Is that good practice for just somebody to say we'll be responsible for that?
I think it's a good practice, because you want to have someone who is going to be dealing with these advertising regulations, which can be very broad, and which involve not only state law but also the Federal Trade Commission. And this is an entity that is like really serious when it comes to protecting consumers. They can start any kind of investigation on their own. They don't have to be called by a consumer. And once they start like looking, they will ask a lot of questions, and they will like really try to make someone pay if they feel like consumers have been deceived. So if you have in a contract that actually Papa John's, for instance, is fully responsible, you may actually show that like you did your part. So I think it's a good practice, not only for your protection in terms of the contract, but also to have like a purpose of compliance, and you will be more protected. And entities, federal or public agencies, are going to be more understanding if you actually have it in a contract, and they understand that you actually were aware of this kind of risk and you kind of address them.
Yeah. Yeah, that makes sense. Well, let's jump down to new co-branded products. This is under D. It seems like it's saying ABG, the company, will permit celebrity Shaq and Papa John's to collaborate in good faith to develop one or more co-branded products. And you mentioned to me in preparation a pizza that they came out with, using the personality rights. Any such co-branded products shall be subject to the separate mutual agreement of the parties. It sounds like it's saying, ABG, don't get in the way of Shaq having some fun with some pizza names. We're going to make a pizza name, and then we'll talk to you about the money later for that other pizza. Do you like the way that they deal with the co-branded product requirement in this section?
Well, I think the problem is that we hope everything is going to go right, basically. Like, if there's litigation, we may have a problem. And it's like they have a clause that says you cannot engage in like advertising or endorsement with competitive products. But at the same time, you have this clause that says eventually you can have co branded products. If something goes wrong, you may end up with the judge who has to figure out what was actually the purpose of the agreement. So if you're going to do something like that, maybe because the possibility is that an advertiser wants to engage on a celebrity and they want to like cover as much ground as they can, because then the celebrity is going to be busy and you don't know what's going to happen in 1 or 2 years. Then you have to contact them again and have them sign another agreement if something is really interesting to put on the table. So they may include that, saying if we come with something great, we may do it, we change. But at the same time, you may have a problem when it comes to interpretation of a contract, application of the contract, if you want to say that something is a breach. If the agreement is not clear, you may have a problem, and you don't want to have the judge figure out what you wanted, especially if the judge doesn't know a lot about your brand, or maybe he doesn't know a lot about what Shaquille considers important for his publicity rights.
Right. Or what the
And the
heck
other
an
thing
influencer
is
is.
that when you have agreement which references to another agreement, you as an attorney should do your due diligence to make sure that all agreements are coherent with each other. So you will need more diligence again, because you need to coordinate the different clauses of the agreements, debts, dates, deadlines, all those kind of things.
I would point out, if you look down in H, sub H, it talks about no dangerous activity, that Shaq doesn't have to do stunts. If you watch TNT's halftime show, you know that at Shaq's size, just running back to the TV screen can be dangerous activity. There is much footage of him running into Christmas trees and falling on his face. Under I, it talks about additional services, and I've faced this as a power influencer, as my son would say as well. That there's sort of scope creep, that people, when you become the Papa John's guy, you start to get associated with a whole bunch of things that aren't necessarily, you guys as part of an agreement. You get scope creep a lot. And I seems to say, there is no scope creep. It is exactly what we said in this document, unless there's some other agreement, but it's keeping the door open to some other agreements in case people say, Papa John's guy, who is that? That's Shaq. Let's go do something. Do you like the way that they sort of try to limit the scope to this document? Is it even realistic to limit that? Because public perception, the point is that it's going to spread.
Well, I think that with that clause, the franchise clause, when they say they may do other things, actually Shaquille is acquiring more risk. So he has these clauses that said, you, Papa John's, are responsible for our advertising content. You are responsible for a product not being risky for the public, not being dangerous, for example. But if you actually acquire a franchise, if you actually are part of the company, let's say you have ownership rights, you may not be in a position to say, I don't have any kind of responsibility, because actually you became the owner of part of that. And if you eventually sit on the board, you're making important decisions, you're part of the making decision process, you cannot say, like, I don't have to respond. And when it comes to like liability, again, for consumers, for third parties who have nothing to do with the contract, that clause probably is not going to protect you. So I think it's better to have an endorsement agreement on one hand and then a franchise agreement on the other. At least when it comes to really, really limiting your risk. You may have a bunch of attorneys then, protecting you. But this again leaves some holes to the fact that he said, I'm not responding for any kind of damages to people or dangerous products. But if you become the owner of something in the company, or you become part of the board, that changes. And that's contrary actually to the, I think, spirit of this endorsement agreement, which is like keep risk control.
Yeah. Well, yeah. I mean, he obviously has multiple relationships with the business at this point. I think I saw an article that referred to him as a triple threat. He'd be that now, in the way he is now, he's got this endorsement agreement, this arrangement. He is the first African American member of the board, and he's a part owner of 9 franchises. He called himself a triple threat. He's got these multiple relationships. And maybe that's normal in these situations. Nobody has one job anymore. They're doing many things, especially if they're in this internet world. And I'm wondering, stepping back a little bit, do you think documents like this are useful just in the multi-million-dollar Shaq context? Do you think they're useful in the much more common context in the long tail of the internet, where people are getting a pair of shoes or some swag or whatever for being an influencer involved with that? Or do you think documents like this are actually going to get in the way of the freedom of transacting that kind of defines those internet relationships? What's the power of contract in these kinds of arrangements?
So I think that we as attorneys don't want like to kill the career of any kind of influencer who probably is going to get famous really fast, and maybe his fame just go as fast as it happened. But on the other hand, if you are actually you become so famous and so important that you have millions of followers, you are going to be in the eye of, again, enforcing agencies. And I insist about that, because when it comes to public advertising, the Federal Trade Commission has always been very strict. Um, so having an agreement in writing, even if it's not as complex as this, can protect you, because you're going to have a document that you can actually present before of a judge or someone and kind of make an argument. If you don't have anything, you're in the hands of, U.S. common law, judge interpretation of the facts. If you don't have anything in writing and you maybe were only like using some phrases during WhatsApp conversations, making very formal deals, it's more difficult for you to protect you. And if you are receiving products from big companies and you are in litigation, maybe you cannot defend yourself also because litigation is very expensive. So, these big companies are going to have any problem to get a lot of attorneys, to defend themselves. But what about you? If you're just starting, you prefer to have an agreement and maybe you don't sign it personally, you sign it through your LLC or a corporation, and you manage your risk. I mean, if you're a small influencer and just like enjoying this like transitory fame, that's fine. But if you really like this and you want to drive more public, you want to create more content, if you think you're going to have a career with this, you should have agreements. And have an attorney who understands what you want, so it's not going to be like in the way of your career. But I think it's important to have these agreements, not as
Well,
complicated.
and it's something that we talked about. I'm thinking about a book by Jaron Lanier called Who Owns the Future? And he talks about the economic inefficiency that these SaaS companies, especially these technology companies, are making enormous amounts of money with very small staffs, in part because they can go to these internet influencers, and a bunch of the customer acquisition work can be done by people online. And so he talks about in this book this huge economic inefficiency that's creating, because the workers who are building the brand are not getting any of the wealth that is going to these brands. I think one of the things that we talked about, and I'd love to get your take on this, is like if you're doing this kind of work, even if you're not famous, even if you're going out there and trying to build your brand, try to get an agreement that gives you some pay for stop getting paid in exposure. Get paid for the work that you're doing, because you're creating value for this brand. That brand should compensate you for the value. And if nothing else, a document like this will help make sure that you're getting compensated for that work. What do you think about a document like this and its ability not just to pay for fame, but to pay for the time that you spent making a video?
I think if you have something in writing, you have a better possibility of getting paid. Especially, for example, in New York, when you have like special regulations for freelance workers. Um, Additionally, I just remember something from the advertiser perspective in New York City. They can be fined if they don't have actually agreements in writing for more than $800 for freelance workers. So even the advertiser sometimes wants to put something in writing. From the celebrity or influencer side, if you have an agreement in writing and it has some money amount, you are in a better position to go and ask for that money. And that may be a reference for you to recover something. If you don't have any kind of agreement or a money that you want to receive in writing, what happens is that how do you prove that your fame or your recognition is this amount of dollars and not what the other party says? If it's really difficult to prove, a judge may be hesitant to actually, give a judgment in your favor. So that's something you want to think about. That even if you start getting paid something, maybe it's not what you want. That's a reference, and that helps you in the future to negotiate an agreement or to defend your rights. Yeah.
Yeah, if even my 14-year-old can't understand what a big deal on the interwebs I am, I certainly don't want a judge trying to sort that out. That would be ugly. Giselle, we thank you for hanging out with us and talking to us about Shaq and Pizza. I could just Shaq and Pizza all day. For people who want to reach out to you and learn more about what you do and documents like this, what's the best way to connect with you?
They can connect with me via, Facebook, which is GAM Law Office, or, they can go to the website. We try to put there a lot of interesting content that can be useful for entrepreneurs and artists, to gamlawoffice.com.
Well, we'll include that contact information and this document on the blog post up at lawinsider.com/resources. And if you want to be on the Contract Teardown Show and beat up contracts like this, you can just email us. We are at community@lawinsider.com. We'd be happy to have you. We'll look forward to that. Giselle, thank you for joining us, and we will see you guys next time. Have a good day.
Thanks so much for tuning in to this episode of the Contract Teardown Show from Law Insider. If you're enjoying the show, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. That helps others find the show. We really appreciate it. Thanks again for listening, and we'll catch you in the next episode.